I'm going to move now to talking about the last major disruptor, regulatory liberalization. And I touched on a little bit when I talked about what went on in the UK, but I was in London in June and I spoke at a conference called Reinvent Law Conference, and my topic is what's stated there, is I was asserting that the ABA needed to get its act together, read the tea leaves, and sit down and form ethics rules to modernize them and to facilitate some order to what's going on in the marketplace. And I was in London, so I thought of Lewis Carroll, and I did sort of a mashup of Alice in Wonderland, as you'll see in a moment. And Dan Carpenter helped me with the illustrations. So in my little story that I told, the walrus is the bar association. The little card soldiers are lawyers who don't want to hear about change, don't want to think about change, don't want to see any change. And the dodo bird, who of course is no longer with us, is sitting at the top of the palm tree. My point was, look, you know, we've got this monopoly, and interestingly, not only do we have a monopoly, but we get to write our own rules. We get to make our own rules and regulate ourselves. So given all that, and we have these sort of scary little fish running around our monopoly, and they're kind of hungry. You know, the clients who we talked about, we got courts and access to justice, who are really big fishes because, as we know, in Washington, the LLT was a creature that just sprung out of the heads of the Supreme Court and on their own motion came to life. And that certainly is a liberalization of regulation when we have a new type of practitioner that has come on the scene. And when the Supreme Court in Washington did this order, they wrote, this is like, hello lawyers, they said, we are not interested in protecting the monopoly of attorneys. And of course, a lot of the bench are access to justice advocates. And right now in this country, there is this massive movement about access to justice. And there are a lot of people in politics and on the bench and nonprofits who insist that if the market is open and the monopoly is eliminated, that a massive amount of innovation will come in and fix all these access to justice problems. The entrepreneurs we talked about, foreign legal services firms who have already gone through liberalization and of course can now compete because they can get $400 million of private equity funding to capitalize their whatever they're doing. And then there's the fed up US lawyers who are tired of waiting around for people to get their act together, and you might guess who one of those might be. So my story was, instead of doing something about this, instead of using our ability to regulate things, ourselves as well as others who are engaged in legal practice, the bar just decides to go fishing. And so it goes and catches this big sea bass and puts it over its head and kind of goes about its business on its island trying to pretend like things aren't happening. And meanwhile, all these fish are eating away at this monopoly and we're doing nothing about it. And then I say, I think the Bar Association should pull its head out of its bass, right? With regard to liberalization, it's actually happening now in a de facto manner. Because as you can see, there are a whole lot of fish swimming around that are doing legal work. And I don't care what they say. They are engaged in the unauthorized practice of law. But there's no consequence. And they know there's no consequence. For instance, LegalZoom's been sued several times in different states, but they always win. And so we're already going through liberalization at a very early stage. There's also pending litigation on the East Coast. A law firm called Jacob Ian Myers has sued courts, judges in New York and in Connecticut. And what they are claiming is that Rule 5.4 is unconstitutional. And this is active litigation expected to go up the appeals chain and to eventually reach the Supreme Court, who in the 1970s, when a case based on unconstitutional arguments reached them regarding lawyer advertising, agreed. It is unconstitutional to restrict lawyer advertising. And that's when lawyer advertising came to life. And then the ABA has always been talking about this in the context of multidisciplinary practice and kind of circling around it. They've never done anything about it. They don't think it, for all the reasons why they don't want to, because it's nice to have a monopoly. There's new leadership now this year who has, the president has indicated that he's very interested in really moving forward and looking at this in a more serious way. And he's created a committee called the Futures Committee. And interestingly, now this is the ABA, the Futures Committee, excuse me, 20% of that committee is composed of Washington people. So our executive director of the WSBA is on the committee, and a whole host of other people. So we have an overrepresentation in this Futures Committee. And then some states will go their own way eventually. If the ABA doesn't do something, if the case in the East Coast doesn't make something happen. So my guess is that Washington will probably be one of the first states to make real changes, to really go a different direction than what has always been the case, which is everybody sort of following rather closely the model rules of the ABA. So in terms of regulatory liberalization, I think that we are probably nearing a tipping point. I used to think it would be a lot longer out, but I think it's actually quite a lot closer in than I used to, where we will see a tipping point. And it won't be like we'll go from dark to light. It will just be something serious will happen. And then we'll start to go down into a period of massive disruption and massive market activity for a while until everything kind of settles into its new paradigm. So what's going on here? These guys know that. They know that in a short period of time, we are going to have liberalization of our rules and that this market is going to be an open market. And these companies and others like them are positioning themselves so that when that event occurs, they can be first movers and take maximum advantage of this massive market that will all of a sudden be open. And they're practicing, right? They're getting all the bugs worked out so that they don't have to do that at the time where the main opportunity arises. So here we have one of my final slides where the monopoly is gone and the Bar Association with the bass on its head is going down, and all the lawyers and with the dodo bird. And we're not going to be with this group. We're going to go a different way.